Let me just. All right. All right. Can you see them?
Yep, we can.
Wonderful. So, my name is Elizabeth Robinson. I am one of 2 attorneys at Hettinger and Robinson PLC, and we use our legacy to preserve yours. What does that mean? It means, let me click here, that Kerry Hettinger and I are related. He's my father. But we have a combined 40+ years of experience in this area of law. I also have 2 uncles who are attorneys. So if we add their combined experience, we're looking at over 100 years of legal practice experience in this area. What is this area? This area means estate planning, estate and trust administration, bankruptcy, and small business planning. We are not, this is kind of my disclaimer, my disclosure slide. I am not a financial planner. I'm not a financial advisor. I am not a tax preparer or a CPA. No part of this presentation is meant to be investment advice, tax advice. It's not a budgeting seminar. What we will be discussing today is debt and the different ways it shows up in our lives. My perspective is from that of an attorney who guides those who are trying to navigate debt. Most commonly, I am helping people navigate debt after the loss of a loved one or incapacity of a loved one, or once their debt has become unmanageable for them. As we go through my presentation, I want us to keep in mind, I think I skipped ahead there. I want us to keep in mind that money is not moral. Debt does not define you. Something that I say probably 3 or 4 times a day, regardless of if I'm meeting someone for estate planning needs, for trust or estate administration, or for bankruptcy or debt consolidation, is the Constitution was written by creditors. They gave consumers, that's all of us, very little protection against themselves. Those same creditors have then put an intense amount of resources into making us feel like debt is dirty. So this is also something, just keep this in mind as we go forward. You know, this whole debt is dirty mentality, it's meant so that we consumers feel that we shouldn't be discussing this in polite society. But now we know better. We know that money is not moral, debt is not dirty. And the whole mentality behind this was created for the benefit of the creditors, not for our own benefit. Okay, and all right. Now I'm going to move my screen around so I can look at my notes a little bit better. So what are our objectives today? We are going to be talking about 4 main points. And Kristen, I am a big talker, so if at any point I'm going over on time, I need to wrap it up, just give me a raised hand or whatever you need.
You got it.
Thank you. So we're going to be talking about 4 things. How do we build knowledge? How do we make a plan? We're going to be talking about action steps. And then the 4th is hopefully going to be my favorite, questions. I love questions. So first, knowledge. Knowledge is power. Wealth is built, grown, and preserved with intention, not by accident. So as we're considering debt in the scheme of controlling it, managing it, and building this wealth, knowledge really is the biggest thing that we need to first be addressing. So number 1, information gathering. When we are information gathering, we need to be thinking about it from 4 different avenues. We need to know ourselves. We need to be honest with ourselves. We need to know our debt. We need to know our motivations, and we need to know our sources. So first, we know ourselves. Millennials are now considered the sandwich generation. What do I mean now considered? Well, previously Gen X was the sandwich generation. Every generation is probably going to be referred to this at some point. What is a sandwich generation? It means this is a generation caring for aging parents while also having very young children. This is a definition of a whole lot of us. If we're not exactly that, most of us can fit into some category there. So we need to know, who is my family? Maybe I'm talking about my parents, my spouse, my children. Maybe I'm talking about a sibling that I care for. Maybe I'm talking about an aunt or an uncle, but we need to know who we're defining in this, because so often with our families, we are also taking on at least some sort of burden of debt for them, if not taking it on completely. You need to know, what are your habits? What are my spending habits? Am I looking at fun things first or second? Am I putting my responsibilities first? What budgeting tools do I use? I'm not going to be making any budgeting recommendations. What works for you will work for you. And then we're also needing to consider, what are you willing to do? This means, are you willing to go speak with an attorney, a CPA, attend a seminar like this? Are you willing to deal with checks? Are you only operating online? These are all things that you need to know about yourself so that you can approach this honestly and straightforward. If you know these answers when you are going to meet with a professional like myself, then our time spent together is that much more productive. You also need to know your rights, not, you're at coffee or breakfast or lunch or sitting at work and so is saying, well, this works for me and this is what I did. That's good for them. What works for you? This could, and most likely should, mean that you're at least familiar with the Fair Debt Collection Practices Act as amended. This can be found very easily online if you go to the FTC website. And this act is the legal guideline for how creditors are allowed to communicate with us. Phone calls are only allowable after written communication, written correspondence. You have to opt in or out of online correspondence. If you're on the phone with a creditor, whether that's the creditor directly or a third-party collection company, everything you can demand in writing. Even if, oh, I sent that to you in writing already, I sent you this letter on this date, that's nice, send it to me again. You are allowed to demand that, and they must comply. And we'll talk about the Fair Debt Collection Practices Act additionally throughout the course of these materials. You also need to know your debt. When you're considering, well, what is my debt? It can feel really overwhelming. So some really straightforward questions to ask yourself is, what do I have? This might mean, do I have a house? Do I have a car? Do I have 2 cars? Do I have any investment accounts? Have I borrowed against those? Do I have credit cards? Do I have personal loans? So start by categorizing it. Secured versus unsecured. A secured debt is debt that is based off of, or you have given an interest in, an item which you own. This might be a mortgage. You purchase your home, but in order to purchase your home, you have to grant an interest in your home to a mortgage company. So you have purchased the home, but you've given this interest in your home to this company so that they will give you money to buy the home. So you should know, do I have a mortgage? Is it a land contract? Do I have any other sort of secured interest that I've granted someone in my home? This is also true for vehicles. Do I have an auto loan? We can also have loans on things like boats. People will take out loans on land, loans on barns. Some will use a vehicle, a home, a barn, land to secure non-related debts. This might mean I'm granting a company or a lien holder, a financial institution, interest in my property so that I can have a loan to pay off my credit cards, to build the barn, et cetera, et cetera. Unsecured debt, these are our credit cards, our personal loans that are not secured. Usually when we're looking at secured versus unsecured, we have a lower interest rate for secured debt, higher interest rate for unsecured debt. The next kind of debt we're looking at is priority versus non-priority. What do I mean by priority? If I'm thinking about it from end of life planning, I'm thinking about payments to or from creditors that are allowable in a certain order. So I might be talking about, again, in Michigan, probate administration. I've got money in this estate. What is the priority debt that I am allowed to make payments on? Versus non-priority. Non-priority debt is going to be our unsecured, most of our unsecured debt. Of course, this is my often it depends answer. Now, if I'm thinking about from the bankruptcy side of things, priority versus non-priority, there's a lot of crossover here between probate or trust administration and bankruptcy. Priority debts are going to be secured debts. They're also going to be tax debt. IRS debt is considered priority. And they're going to be in both bankruptcy and in probate, priority debts will be any monies owed to friend of the court or spousal support if there's a domestic support order. There's also going to be a priority debt. This is more at estate planning. If you owe any monies to a funeral home or any sort of outstanding invoice for end of life care costs. Know your motivations. So what have we done so far? We've gotten to know ourselves. We've gotten the reality of ourselves. You know, not everyone's reality is the same. When I'm holding estate planning meetings, and this is something my dad trained me on, so you can imagine, it kind of made me laugh. He would say, if you're choosing your trustee, your executor, your personal representative, you're thinking about one of your kids maybe, you don't go with your oldest. You choose your least favorite, yet most responsible child. Well, you can guess who his trustee is. It's me. So thanks, Dad. I'm one of 4. But really, what does that mean? It means I know that this is a job. This is a task. It's a burden. This is not I'm his favorite. This is not I get the stuff. This is I have to deal with the nonsense makers. And so this is true when we're considering ourselves. I need to know if I'm willing to deal with nonsense makers. Am I willing to deal with family members and being honest with them and being patient with them? So you need to know what your limitations are, what you're willing to take on, what you're not willing to take on. Second, we needed to know our debt. So we know ourselves, we know our debt. In an ideal world, which it should be, but it isn't always, we're writing this down. And we're writing it down in one place. I can tell when people come in if they have ADHD or not. My husband has it, so I know what it looks like. Sometimes people are coming in with their Meijer bag full of paperwork. Sometimes it's crumbled. Sometimes they say, oh, that's filed in my dashboard. That's where I file everything. I don't care where you keep it, but have all your paperwork, have it together, write it down. Because our next task here is to know our motivations. What are our goals? What's important to you? Everyone and their mother is going to tell you what they think is important and what should be important to you. But the only person who can answer that question is you, because the only person that's going to testify on your behalf, the only person that's going to advocate for you, the only person that's going to make your payments, that's going to sign on for more debt, the only person taking the liabilities and securing their own assets for more debt is you. Maybe your neighbor Susie says, yeah, this is what I did. It worked great for me. But maybe Susie is willing to take on more or less liability than you. So you need to know what works for you. What are your goals? Do I want to pay off all my debt first? Do I care more about growing assets than paying off debt? These are conversations that you need to have with yourself, with the people you trust, and hopefully with your team of financial professionals. You need to know what your short-term goals are. You need to know what your long-term goals are. I don't care how long your long-term goals are, but they should be longer than your short-term goals, right? You also should have some developing goals. These developing goals, these are what I kind of consider to be the longest term goals. So for me, a short-term goal might be, I know I want to do this in 6 weeks or 6 months. A long-term goal might, for you, be 6 months or 1 year. That developing goal is going to be changing. It's going to be adjusting itself as your short-term and long-term goals are either achieved or modified. Your developing goal might be, I want my mortgage paid off in 10 years. Your developing goal might be, I want to make sure that my income is such that I can pay my student loans. Your developing goal might even be, I need to get on or off of this IBR because I know that my household income is going to be increasing when I get married in a year. So these are all of your goals. Again, what are you doing with these? You're writing them down. I should have said this in the beginning. Everything we're talking about here, you should be keeping a record of, whether that's on a yellow pad of paper, a legal pad, whether that's in your spiral notebook, whether that's in your Google Drive or in your Microsoft Word document, wherever it is, keep it the same, keep a record, date it, maintain your conversations there, keep summaries. And make sure that you're writing all of this down. What am I willing to do? Because what I'm willing to do on January 21st, 2026 might be very different than what I was willing to do on January 21st, 2020, and might be different than what I'm willing to do January 21st, 2030. So make sure you're keeping records and notes of all of these things. You also, as you're knowing your information gathering, know your source. I am not exaggerating when I say that once a week, minimum, someone sits down at my conference room table, pulls out their phone, and says, hey, I see this guy talking on Instagram. What do you think about this? Or so-and-so said this. Here's the reel they sent me. Please know your source, vet your sources. Where are you getting your information? Are you getting your information from your neighbor? If so, where are they getting their information? From their lawyer? Have you verified that? How can you fact check that? Is the source getting paid for giving you this information? That's neither good nor bad. That's kind of a neutral piece of information, but it's important to know because if they're getting paid or you are paying them for this information, that's going to help you understand their motivation. Are they trying to sell you something or is this truly what you need? When we're thinking about our virtual information sources, this could be influencers, this could be some information that you purchased through an online source or a website. Where's the location of this source? The information they're giving you, the documents that have been generated for you to complete. Where were they drafted? If you live in Michigan, are these Michigan compliant documents? When we're looking at both estate planning and bankruptcy, we are looking at both federal laws and state laws. So the rules that are going to control in Michigan are not the rules that are going to control in Indiana, in Utah, in Wyoming, in California. They all are going to look different. So know your source, know if this is a document that is appropriate for you, if the information is appropriate for your state and the region of your state in which you live. Is this source educated on the topic? What does that mean? Not all education is a formal university degree. Sometimes it's apprenticeship. Sometimes, yeah, I've worked in the industry for 25 years. Sometimes these sources will say, well, I did it myself. Well, that's good. But remember, at the beginning, we said we have to know ourselves, and what works for Sue probably is not going to work for Elizabeth because we're different people with different motivations, different backgrounds. Maybe we have different parents. Maybe Sue's mother needs financial support or might need to move in with Sue. Elizabeth's mother doesn't. Maybe Elizabeth's mother needs to move in, and Elizabeth says, no way, you're not moving in with me, Mom. You know, so everybody is different, and we need to make sure that we're considering this when we're watching some of these reels and looking at some of these influencers who are saying this worked for me, that worked for me. This is also true with the pre-influencer. These are the financial advisors and financial planners that were big on the internet before we had social media. You probably know at least one person that I'm referencing. These sources are excellent sources, but must be viewed through the lens of, is this doable for me? Does this work for me? What are they gaining by doing this? As a bankruptcy office, we have been contacted by at least 5 big financial influencers who push debt-free and bankruptcy is evil. And then all 5 of these influencers contact us and other bankruptcy offices and say, hey, don't you want to be part of our preferred bankruptcy attorney list? If you pay us this money, then we'll make sure our people all come to you. We'll put you on our search engine. So keep that in mind. These influencers are not really out to help you as much as they are out to help themselves. They may be saying bankruptcy is evil, don't file it, use my products until you're blue in the face. But then they want me to pay them so that when their product fails, you come and file bankruptcy with me after paying all this money. And we're going to talk about that a little bit more later in this presentation when we talk about some different options for debt consolidation. Next step is to make a plan. I'm going to take a sip of water here. So, common, we've all heard it said, hopefully, fail to plan, plan to fail. Planning is intimidating. It feels overwhelming. It feels like it's this huge, awful task to confront our own realities and make steps to go forward. However, if you are not doing it, you are planning on failing. So, how do we make our plan? We're going to learn from the past and plan from the future. This goes back to one of our first slides. Know yourself, know your reality, know what has not worked for you. If you have approached, and this is not a comment on the debt snowball, if you have approached the debt snowball method 16 times and it has not worked for you, you need a different approach. If you have approached the interest rate method where you're paying things down based on interest rate and that has not worked for you, you need a different approach. If you have approached the method where you just stop using your debt and you're using only cash, and that's not working for you because of the lifestyle creep or whatever your obligations are, you need a different approach. So, how do we plan for the future? We need to review our expenses. This goes back to knowing ourselves. Write it down. Again, spiral notebook, put it in a spreadsheet. You can use a fancy budgeting software. People do it and are successful, but you also need to know, can I even afford to pay for this? Sometimes Google Sheets or writing it out by hand, the free option, if it's a free option for you, is the best option. It's the best place to start. Then you decide to use a software, great, but write it down. Create your budget. When I am looking at, oh wait, I'm skipping ahead. These are the things we're going to be talking about. So review your expenses. I've already talked about some of these. Record keeping is key. If you are not record keeping, this is very common. Again, I mentioned I do a lot of probate administration. This could be someone has passed away, or this could be someone has become incapacitated. Your person, the person that's going to come in and pay your bills for you, know what you have. If you don't have a record, they're not going to know how to pay your bills. An real life example in my practice is a 37-year-old woman was in a car accident about 1.5 years ago. She was the record keeper for the household. She paid the bills, she managed the expenses. And when she got in this car accident, she went into a coma. It's very sad. She's still in that coma, and her medical team expects that she will not recover from this vegetative state. Her spouse had no idea. He didn't know what bills they had. He didn't know how much money they had coming in. He had just said, yep, my wife takes care of this. So he ended up having to get a conservatorship to file bankruptcy on behalf of his wife, who had managed all the debt, put it in her name, and that included their home was only in her name. So keep records. If the worst happens, and for someone, the worst might be death, it might be incapacity. The worst also might be financial devastation. If this happens, having records will take you so much farther, so much faster. Remember that there is a no one-size-fits-all approach. What works for you probably won't work for me because we're different people with different lifestyles and different needs. Keep all of your household contributors informed. Think to the example I just shared. Any adult that contributes to the household, that lives in your household, keep them informed of what your debts are. There is a very good chance that they're going to need to answer questions about that. They'll need to know the truth of whatever situation is, not that anyone is lying or hiding, but sometimes out of pure embarrassment, or I think, oh, I've got it. He doesn't need to know. I might not tell someone, but if something happens to me, they need to know what's going on. Know your different kinds of expenses. What kind of debt do you have? There are a couple different kinds of debt. Now, these are not legal terms. These are just terms that I've seen used in common conversation that my clients bring to me. So we have consumptive debt. This might be debt that I'm using or taking on to pay for my groceries, my mortgage payment, my car payment, things I need to continue. I might have more rotating debt like a credit card. I rack it up, I pay it off. I rack it up, I pay it off. So make sure that you know what kind you have. Keep it categorized. When I'm categorizing my own information, I keep mine categorized by security, house, car, who's on what. Is it both me and my husband, or just one of us? So review your expenses, keep it all informed, keep it all in one place. Create your budget. Experts agree, comfortable yet modest budget. When clients are coming in and they're saying, I do a lot of estate planning for millennials and up, I think my most common age right now is 67, but I'm getting a lot of younger clients. They're coming in and they're saying, I don't even know how to make a budget. Where do I start? How much money do I put for this or that? The best advice that I can give you from a legal standpoint is keep it comfortable yet modest. And also be realistic. Maybe this month, I don't need to buy clothes. Well, the season's changing. My go-to clothes might be wearing down. I'm probably going to have to buy clothes. So when I'm creating this budget and I'm being honest with myself, I know that in the next 12 months, I'm probably going to need to spend this much money on this thing. I do this with my estate planning clients. And if they want more detail, I say, okay, time to go to a financial planner. And if I'm working with my bankruptcy clients, a big part of that is what can you actually afford? We have to prove that you cannot afford to make these payments. So I put a budget together for them, comfortable yet modest. Avoid the lifestyle creep. The lifestyle creep comes for us all. Social media makes us feel inadequate. I might watch someone's Instagram page or TikTok reel, and they are a lawyer my age and they're driving a Porsche. I don't have a Porsche. I want a Porsche. Maybe I feel like I need to go out and finance a Porsche. I'm a partner here. I should be able to afford a Porsche. Well, maybe I can't afford a Porsche. Comparison is the thief of joy. Comparison is the fastest route to financial ruin. Avoid the lifestyle creep. If you have been honest with yourself, if you have written all this down, you know, yeah, maybe that looks great. I know it's on sale on TikTok Shop, but I've already used the money for this other thing. I don't really need it. Knowledge is power. So often, clients will come in here, especially for bankruptcy. I do see it with estate planning, but especially for bankruptcy or debt consolidation. And what they're saying to me is, I didn't realize I'd already bought 2 of those, or, oh, I guess I did sign up for that debt consolidation already, or anything like that. So keep yourself informed. That is the best way to avoid the lifestyle creep and maintain your comfortable yet modest budget. And when you have no debt, your budget goals can change. Understand your debt. We talked about this a little bit. Consumptive debt, crisis debt. A crisis debt might be you have a credit card that you only use for emergencies. You have an emergency, you swipe it, you pay it off immediately. Debt consolidation. We're going to spend a little bit of time talking about this. Debt consolidation, there's 2 kinds that I most commonly see. I see debt consolidation loans where you are taking out a loan with a financial institution, sometimes unsecured, sometimes secured. What this might look like is a home equity line of credit or a home equity loan. Sometimes a debt consolidation lien is taken out through specific debt consolidation companies. Be very careful here. Debt consolidation, know your debt. Sometimes with student loans, for example, you could be taking out a debt consolidation loan to pay off your student debts. But if you are not aware of what your student loans are, and if you are not aware of what this new lien will be, sometimes your interest rates can skyrocket. Or if you have any sort of deferment, you've been receiving any sort of deferment or benefit, this might be a deferment of interest rate. This might meaning you're on an IBR, or if you have federal loans or PERC loans or private loans or Parent Plus loans or Grad Plus loans, sometimes having debt consolidation loan pay those things off means you have an unrealized gain from forgiven interest that now you're going to have a tax consequence for. So the best advice I can give you here from the legal standpoint, if you are considering a debt consolidation loan, go speak with your financial team. This might be or should be your tax preparer or CPA. It might be your estate planning attorney, might be your bankruptcy attorney, or it might be your certified financial planner. Those experts, as long as they're properly licensed and they're working in your state, this is not the online lawyer from Texas, because they're not going to be able to answer my Michigan questions. They're not going to know necessarily what the inheritance law is in Michigan or the gift tax limits. So make sure that your experts are local to you and talk to them about it before you sign on the dotted line. Once you sign, you can't take it back. I also want to talk about predatory debt. Same day as cash, payday loans, high interest rates. When I'm filing bankruptcies for people, I see a lot of the same companies. Sometimes someone comes in and I'm putting together their schedules and I'm seeing, I'm not going to name any names, I'm seeing this credit company 15 times. What have I been seeing most commonly in 2026? Debt repayment programs. These are programs where you have this company take money out of your paycheck every month, and then they snowball or pay off your loans or your debt in the way that you two agree upon. Know what you're getting into here. I'm going to say it again. Know what you're getting into here. This may work for some people, but so often these debt repayment programs, this is not what I'm talking about is a debt consolidation loan, but I'm talking about a program where you send the money and they pay off your debt. They will first pay themselves. That's the first thing they do. And then they pay your creditors. And sometimes that means bottom tier creditor is not getting paid. They might not be transparent with you about that. It's up to you to monitor that. At least 6 times so far this year. It's been 21 days and I don't work on the weekends and I don't work on Mondays. So 6 times this year on the days I've worked, I've had a bankruptcy client come in and say, I was paying this debt repayment program. I was making my payments on time, but I got sued by this creditor, or I got served a summons by this creditor, or my car got repossessed. I don't understand. We look through it and it turns out that they were making enough payments to pay for the debt repayment program and then maybe 3 of their 10 creditors. And in the disclosures they signed, they said they understood that. And so what did their debt repayment program tell them to do when they called and said, what the heck, I got sued? They said, go file bankruptcy. 2 of these programs had even guaranteed legal representation if they got sued. Both of these programs, when the client called and said, I'm getting sued, you said you'd give me a lawyer for circuit court, said, oh yeah, we don't actually have someone for you, go file bankruptcy. So before you sign anything, read through it thoroughly and don't be afraid to consult with a financial professional. Even if you don't have a relationship with a financial professional, Google somebody, ask your mom or your dad or your sister or your neighbor, who's your estate planning attorney? Who's your CPA? And then, sorry, I got distracted here. I'm going to answer your questions. Once you have those answers, call them. Ask if they offer free consultations. Most of them will. Take this information there and say, is this a good idea for me? If it's a bad idea or a good idea, they're going to be honest with you. Plan for the unexpected. Estate planning and bankruptcy. So with estate planning, how can we plan for the unexpected in the kind of grand theme of debt management? So often people pass away and we see a huge violation of the Fair Debt Collecting Act. What does that mean? Mom had a credit card and the credit card company is now calling me, daughter, and saying, your mom owed us $12,000, but if you pay me $800, I'll forgive the rest. No, that is not how it works. They are violating the Fair Debt Collection Act. They are not allowed to do that. They know they're not allowed to do that, but they do it anyways. When these credit card companies, and this is a spiel I get on kind of my soapbox about, when these credit card companies give us credit, they charge us these exorbitant interest rates because they're taking on the risk that I could get run over by a truck tomorrow and they're never going to get their payments. Never. They take that risk, and that is why they make us pay them these high interest rates. So by having testamentary documents, we can potentially avoid probate administration and potentially avoid having creditors begin to harass, state claims that are inappropriate, etc. What are testamentary documents? Last will and testament, we all know that one. And then trusts. I'll kind of give you my review because I can see we're running a little bit close to time perhaps. So a last will and testament is a document that guides and directs probate administration. I'm going to say it again. A last will and testament is a probate document. It will not avoid probate. It used to in the 80s and 90s, not anymore. A will goes to court and means it's going to guide court. A trust, we put our money and our assets, our home, our accounts into our trust. We name the trust as the beneficiary. And then once our trust is the beneficiary, when I'm run over by that truck, my asset just stays in my trust. My spouse is the other beneficiary, or my kids or my dog. I do a lot of pet planning, a lot. I pet plan in my own trust for my cats and my dog and my chickens. I make sure that they're all provided for because they're important to me. And in the trust, it says, so-and-so after I die does blah, blah, blah. Most trusts are not going to give you tax implications in Michigan. Most. If you are seeing someone advertise for a crazy name trust, they're making it up. They don't have crazy names. Most commonly, we see revocable trusts and irrevocable trusts. Unless you have a disability or you are planning for Medicaid in the next 5 years, you do not usually need an irrevocable trust. You would look at a revocable trust. You can transfer your assets into your trust, even if there's still a lien on it. I can still put my house in my trust. I just use a different kind of deed. We make sure our assets, I'm going to go down to number 3 here, are funded into our trust. Powers of attorney. In Michigan, we have 2 kinds. We don't have a living will in Michigan. We have a healthcare power of attorney. This says, I'm incapacitated. This is the person who can make healthcare decisions for me. And then we have a durable power of attorney. It says, I'm alive, but I'm not competent. This is the person that can make financial decisions for me, including taking out a loan in my name, suing someone in my name, emptying my bank accounts. In 2024, Michigan adopted the Uniform Power of Attorney Act, which is incredible. It's so protective, and we are really seeing protection for our vulnerable adults. It was a big movement by the Vulnerable Adult Task Force in Michigan. I think it's wonderful, but our powers of attorney must be in compliance. So if you have more questions about those or you want to decide if they're right for you, if you're wondering when should I make a will, my answer is, are you 18? You should have a will. In Michigan, you can't make one until you're 18. Everyone should have some basic estate planning documents or at least have had the conversation with an estate planning attorney in their state. We also plan for the unexpected with bankruptcies. The very beginning of this, I said the Constitution was written by creditors and they gave us one protection from themselves. And then they put a bunch of time and money into telling us, ew, that's a gross thing to do. That's bankruptcy. In the Constitution, it's called debt reorganization. There's two types that are meant for individuals. There's a lot of types of bankruptcies, but two types for individuals. A 7 is the wipe the slate clean, and the 13 is a 3 to 5 year debt repayment. A lot of those debt repayment programs that I referenced are modeled after the Chapter 13 bankruptcy. The big difference is the Chapter 13 bankruptcy keeps your home, keeps your cars in most situations. I have filed these bankruptcies for other lawyers, for doctors, for engineers, for judges, for people who work in manufacturing. Everyone, no one income earner, no one person has not needed the benefit of this Chapter 13 bankruptcy. And we determine what you're eligible for based on your family, your income, your debt. There are debt limits that we have that have to be met. And then in those bankruptcies, we can have exemptions to protect your property. We would determine, of course, if you are eligible for Michigan exemptions or federal exemptions, but we don't have time to jump into all of that. So if you are thinking about bankruptcy, step number 1 is go talk to a bankruptcy attorney. The best advice I can give you here is make sure this bankruptcy attorney commonly files in your court. Michigan is split into 2 federal districts, Western and Eastern. If you are filing bankruptcy, your attorney should be licensed in the district in which you live. We are licensed in both the West Side and the East Side. And they should be from your region. In the Western District of Michigan, which is where I'm located in Kalamazoo, we have a very civil bar. In fact, Carrie Hedinger, my partner here, he was awarded the Civility Award a few years ago, which means both the debtors bar and the creditors bar and the bankruptcy court all agreed that he is was at that year the most civil attorney in the Western District of Michigan. That is such a high honor. But make sure wherever you're going, whomever you're consulting with is local to that area. Most of the time, a bankruptcy consultation is not going to be any cost. Some of them are, just keep that in mind if that would be prohibitive for you. Take action. You are your own best advocate. So, what have we talked about so far? You need to have some knowledge. You need to make a plan. And then you're going to learn how to tie your shoes. We can't walk until our shoes are tied. You're keeping your records, you're staying informed, you're building your professional network, and you're not afraid to talk about it. You're not suffering in silence. Your records do not need to be fancy. With those records, keep your most recent statement for each item of debt and for each item of equity, your bank accounts, your investments. Make sure you have up-to-date numbers. If you don't want to keep paper statements, then on your spreadsheet, you have the category, the date it was updated, your initials next to that date, the value, the interest rate. Make sure all of that information is at your fingertips. For items like secured debt, keep estimated payoff information so that you know, put it in your calendar. I know that I make my final payment on this day, and then I know to expect my lien release. Have your equity estimates. If you own property, any real estate, then in your tax assessment that you get twice a year, there is a number on that paper called the SEV. Most legal principles, most legal sources and guides will tell you your rough estimate of your property is 2 times that SEV. That's going to be lower, I'm just telling you, that's going to be lower than your Zestimate or your Zillow estimate. That doesn't mean that that's what your house is going to sell for. That's not necessarily your fair market value. But as far as many legal considerations, that is the value of your home at the time, maybe not the sale value. So whether we're doing probate administration, trust administration, or bankruptcy, we are taking 2 times the SEV for that year. Stay informed. Monitor verified sources. Once you have gone through those action steps at the very beginning, those knowledge steps, and you know, yep, this person I like to get information from, they're a verified source. Monitor them. As you monitor, continue to confirm that they are verified. Every once in a while, double check their credentials. As you change, your needs change. So stay informed on those needs. Maybe your house is paid off. Maybe you had another child. Maybe your mom or your father or your relative has some early signs of cognitive decline. Don't let that stuff surprise you. Maybe you have a variable interest rate loan. Stay informed of what that means. Know your amortization rates. If you own real estate, know what an amortization schedule is. That comes to you at close, and that's your projected debt payoff of your home. It shows you your principal, your interest, and how much your principal is being paid down with each payment. Understand that if you make, sometimes you'll make your early payment, a lot of times at your close for your real estate, they'll tell you, make one extra payment a year and it's going to pay your house off 15 years faster, or something like that. Make sure you ask, is there a prepayment penalty? Are there going to be penalties? What could my tax consequences be? It's always okay to ask. And if the professional you're asking doesn't know the answer, their response should be, I don't know, but let me find out. If it's not, you may want to seek a different professional. Read your mail. Don't let your mail pile up. Very, very commonly, I'm going to say 90+% of the time, when people come in with mom or dad's estate or spouse's estate or neighbor's estate or aunt's estate, or they're coming in to talk about bankruptcy, they're coming in with a plastic grocery bag full of unopened mail. Don't be afraid. Don't be intimidated. Easy to say, right? But open your mail and read it. Sometimes it might be notices that you can just shred. But other times it might be a notice of something that is really impactful to you that you need to know. That's why they're sending you the mail. Don't be afraid to ask questions. If you get a statement that makes you wonder, is this legal? How can they do this? Call them and ask. Call a lawyer and ask. Most lawyers are happy to answer your questions because if they can answer your questions thoroughly, even if you don't need them today, you're going to remember how thoroughly they answered your question and give them business in the future. So lawyers will answer your questions. CPAs, financial professionals, they want to answer your questions because if they can impress you with their thorough answer, you're going to remember them. This leads us into building your professional network. Keep your financial house in order. Make sure your financial professionals know each other. Make sure you have a financial professional, even if you don't have a relationship with someone. Maybe this is your CPA. You know that you go to this guy, he files your taxes. He's also a financial investor, but you don't use those services. That doesn't mean you can't ask him questions. Get reviews. Most professionals will give free reviews or low-cost reviews. Have your documents reviewed by a professional once a year. Your family will thank you for that. Maybe you feel competent reviewing them. Great. In your notes, you write down, reviewed this date, made these changes. If you are seeking a professional, make sure they pass your vibe check. If you go into their office, it doesn't matter if your neighbor says they're great. If you go in and you feel uncomfortable, they don't answer your questions thoroughly, you feel like they're kind of shirking you, giving you non-answers, go somewhere else. There are many lawyers, there are many CPAs, there are many financial professionals. Find one that's honest with you, that you feel comfortable with, and that's going to give you as much information as you need, and probably more information than you need, because they want you to be prepared. And talk about it. Money is not moral. Money is not moral. Gone are the days when talking about finances is not something we do in polite society. With the state of bankruptcy filings, with the fluctuations in the economy, we are not isolated. Although we often feel that way, we can have these conversations, even if it's going to your workplace, someone like Kristen, and you're saying, Kristen, I need help. I don't feel well. I don't feel healthy in this regard. Please give me some advice. She'll make sure that if it's not someone that she herself has a relationship with, that she follows the proper procedure and that you are cared for. That's the whole point of this, right? So don't be afraid to ask. There's always someone to ask. If your debt feels unmanageable, make a plan before the spiral begins. We often have people come in and they say, I feel like I'm on the path for bankruptcy. Carrie and I do a review, and sometimes the answer is, look, you have a lot of excess spending. You're not going to qualify for a bankruptcy, or I don't think a bankruptcy is worth it for you because you could easily pay some of this debt off, or you need to put money here or there. Or sometimes people come in and they say, my mom has these overwhelming bills. I'm caring for her now. What do I do? And we're saying, well, it might be time for a bankruptcy. It's not moral. Your debt is not a reflection on you. It's a reflection on the society in which we live, which we are all susceptible to. So please talk about whatever is stressing you. Find a trusted professional. There's always one out there. And if they don't pass your vibe check, go somewhere else. So your key takeaways: knowledge is power. If we fail to plan, then we plan to fail. It's never too early to talk about it, and money is not moral. If you have any questions, this is how you can reach me. All right.
Thank you so much, Liz. Are you able to see the chat, or do you want me to ask them for you?
Yeah, I can see it.
Okay.
So, student loan debt. Ooh, that's a hot topic. Everybody asks about it. Me too, right? We've all got student loans. So, student loans are considered unsecured priority. Priority. So they're not secured by something, but they have priority treatment. When I was in law school, I did my externship with the branch of the bankruptcy court, and I wrote this huge article on student loans. At that time, and still now, student loan treatment is often in a bankruptcy, and student loan treatment in estate administration gets priority treatment, meaning it gets paid first or is undischargeable in bankruptcy, greater than IRS debt. Isn't that crazy that we treat student loan better? We treat student loan debt, better than some IRS debt. I think that's cuckoo bananas. But here we are. So it is priority debt, often non-dischargeable in a bankruptcy. But let's say you file a bankruptcy and you have student loan debt. Sometimes, depending on your situation, what we can do is we can pause your interest, or we can cram down interest during the lifetime of your bankruptcy plan so that you can pay off everything else and then readdress those student loans when you have a better grasp on your income and when you have the ability to make those payments without damaging yourself. This is also, and something I'll comment on here too, if you're filing a bankruptcy, very often we can also keep mortgage payments or car payments outside of the bankruptcy so that your mortgage, your car, they're not getting touched by the bankruptcy. You can make your payments as long as you can. Make those payments on your mortgage, on your car, keep those assets, nothing there changes. So there's a lot of different options. Second comment is vault password system and encrypted docs. Great, if that works for you, awesome. What happens when you file for bankruptcy? Well, it depends. There's two kinds of bankruptcies that affect individuals. There's the 7 and there's the 13. I couldn't answer which is right for you unless we spend probably an hour talking about your situation. You bring me a whole lot of paperwork. We put it all together, we review it, and then we get your paperwork filed. Sometimes that means with the 7, after certain milestones are met, such as filing fees paid, a meeting of creditors happens, then you get a notice that your debt has been discharged. That means that you no longer have to pay it. Of course, we all know there's damage to your credit for some amount of time, but it's not forever. And being delinquent on these bills sometimes is equally as damaging. With a 13, you make a payment directly to the Chapter 13, you make a payment directly to the bankruptcy court's trustee. And then the trustee, based on a plan that me, the attorney, prepares and the creditors agree to, make payments to pay off some portion of your debt. And that portion is determined by your liquidation value, liquidation analysis based on your assets. So I know that's kind of a question that begs more questions, but that's kind of my best summary in the time that we have. A good time to start making a will right now. Make one right now. We have a lot of different kinds of wills in Michigan. The last will and testament. And then we also, if you can't, for whatever reason, go see an attorney, there's also something called a holographic will. A holographic will is handwritten. It has to meet certain elements. What I do not recommend is a ChatGPT will, an online generated will. I know a lot of companies advertise for that. A lot of famous people advertise for that. I will be very frank and tell you the cost of the online estate plan is not very different from the cost of an attorney prepared estate plan. They sell you on a whole bunch of stuff and then they underfund. That means they don't follow up with you on the trusts that you generate. They say, yeah, this trust is going to keep your stuff out of probate. It's going to make sure your creditors can't touch your money, blah, blah, blah. That you pay for it, only a couple $100 less, sometimes more. Some online generators cost more than what I draft, and they're not always attorney backed. And then you pass away or your loved one passes away, and it turns out none of your assets were properly put into your trust, and now you have the cost of probate. You go back to this company, and what do? They say, oh yeah, use one of our probate lawyers. Yep, yep, yep. So when, again, this goes back to know your source. Doesn't matter who's advertising it for you. It doesn't matter what they say. Ask questions. Know what their motivation is. Almost all of the online trust and will power of attorney generators are not going to give you, most of them are not going to give you a Michigan attorney to consult with, and they are not really protecting you from probate administration. Instead, they're giving you a little bit smaller upfront cost, maybe, and then they're connecting you with one of the attorneys that pays them to be in their search engine system to have you pay them way more for a probate administration. So be very, very mindful when you are using anything online. A lot of attorneys, myself included, are happy to do virtual consultations, phone consultations. So check in on that first before you sign off on any sort of online document. Oh, the other benefit of using an attorney is, let's say there's an error or something goes wrong. Your loved ones can come back to me and say, what the heck happened? And if it turns out there's an attorney created error, I'm going to go fix it and I'm not going to charge you for that. But if it's an online document, there's no one to blame. And you're going to have to pay a whole lot to get that fixed. The act I mentioned earlier about a past loved one's debts. So hold on. How do I close this bad boy? There we go. Is my screen still sharing or no?
Yes, it is.
Let me pull it up here. The Fair Debt Collection Act, and I've got it. Now I'm gonna do this, and I am a tech Luddite, so very impressed I'm doing this right now. This is the Fair Debt Collection Practices Act. Look, ftc.gov. How did I get here? In my search bar, I typed Fair Debt Collection Practices Act. This act controls what creditors are allowed to do, how they can contact us, how they can try to collect against us. It's very thorough. There's a table of contents. I don't expect that anybody really can go, oh, what do I need to know about this? And really interpret this for themselves. But if someone is harassing you and you say, look, Section 806 of the Fair Debt Collection Practices Act, subsection 1 says, blah, 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 they're probably going to leave you alone and give you time to go talk to an attorney. This act speaks to probate administration as well as collection against individuals. So if you have questions about that, spend a little time, gather your questions. I'm happy to answer them. There are exceptions, of course, if someone is kiting checks or if there's fraud that can be provable, then creditors can act outside of this act, but the opportunities for them to do that are very slim. All right, I think those were the questions. Any other questions for me?
I am currently not seeing any come through. If you guys do have further questions, you can either send them to me and I can, forward them on to Liz. Again, with the stipulation that she is located in Michigan. So if you are in Nebraska or you're from a satellite location or from Utah, make sure you consult with somebody in your local area. Otherwise,
Kristen, I'm sorry.
Go ahead.
Can
Go ahead.
I add on that? I am part of the federal bar as well as the Michigan bar. So if you don't know how to find someone in those areas, I very likely can find a trusted professional in that area for you. I have contacts all over the United States.
Awesome. I did not know that.
Yeah.
But otherwise, oh, well, somebody is asking for names for Utah.
Is that estate planning, bankruptcy, or both? I'll send names for both to Kristen.
Perfect. Gus, I hope that's helpful. Estate planning.
Okay. Yep, I will. What I'll do is I'll reach into my listserv and find some reputable attorneys, and then I'll send them to Kristen to share.
Excellent. Appreciate that.
All right.
All right, guys. Well, I hope this was beneficial for you. I will have this recording up as soon as I can. And Elizabeth, thank you so much for joining us today.
Yes, thank you so much for having me.
All right, guys. Have a great day.
Thank you, Elizabeth.
You're very welcome.